6 agency number 7, Mr. R.J. Goswami.
Yes.
Please, Maharaj. I may be permitted to appear on behalf of Mr. Goswami.
I am on behalf of the respondent. Mr. Ray.
Cancellation.
Yes,
Please, Maharaj. Please cancel.
Date of the order.
Date of the order 23rd September 2017. Maharaj.
What is the stage?
Maharaj, it is pending, and the next date of the trial is 18th. In the next month, 18th. It is for the evidence of the prosecution. Maharaj.
Any violation?
no worries. Challenge it on merits.
Yes. What are the submissions?
Please, Maharaj. Annexure A, page number 1 is the FIR. Maharaj. The date of the incident is 22nd 6 2017. Maharaj. On 23rd, the FIR came to be registered under the provision of 338 of the IPC and 135 of the Gujarat Police Act. The brief case narrated in the FIR is that the accused, respondent number 1 hearing, had fired 2 bullets from his licensed firearm, and 1 bullet got shoot to the relative of the petitioner who got injured. And I have mentioned in my petition at page number C, my lords, that the victim's leg had to be amputated from his tights, my lords,
Yes.
on 26th July 2017. My lords. Initially, the FIR came to register on 338 my lords, under the IPC.
Yes.
After that, the investigating officer had submitted a report for addition of section of 307 of IPC. Therefore, as previous offense is bailable one, the respondent number 1 was enlarged on bail by the police officer. Malus. Thereafter, 307 came to be inserted. Therefore, he has approached the Sessions Court for anticipatory bail. The order is at page number 22. Malus.
Yes.
If my lords may kindly turn to page number 25, the reason assigns while enlarging on anticipatory bail by the Sessions Court. May I permit it to read?
Yes.
Please, ma'am. આ કેસની સંપૂર્ણ હકીકતો જોઈએ તો હાલનો બનાવ તારીખ 22/6/2017 ના રોજ બનેલ છે અને બનાવમાં જાનૈયાઓ લાયસન્સ વાળી બંદૂકમાંથી ફાયરિંગ કરતા બંદૂક નીચે નમી જતા ઈજા પામનાર નરેશભાઈ who is the relative of the petitioner, બંદૂકના છરા બંને પગની સાથળુ ઉપર અને ડાબા હાથના પંજા ઉપર વાગેલ છે. શરીરના કોઈ વાઇટલ પાર્ટ ઉપર ઈજા થયેલ નથી. My lords, I have mentioned in my petition that on 26 the victim's leg was
amputated.
Please, my lords, please. બનાવને 3 મહિના જેટલો સમય થઈ ગયો છે અને ઈજા પામનારને દવાખાનામાંથી ડિસ્ચાર્જ કરી દેવામાં આવેલો છે. આરોપીની કસ્ટોડિયલ ઇન્ટ્રોગેશન તેની પ્રથમ અરેસ્ટ વખતે જ પૂર્ણ થઈ ગયેલ છે. હાલના કિસ્સામાં માત્ર રીઅરેસ્ટ કરવા પોલીસ માંગે છે. My lords, here the London Sessions Court has not considered the affidavit filed by the investigating officer why the custodial interrogation has been necessary. He has not, the London Sessions Court has not considered the affidavit, nor he has mentioned about the same in the order, my lords. The second aspect is this, my lords. તે સંજોગોમાં ઉપર મુજબના પેરામીટર જોતા આ કિસ્સામાં ગુનાની ગંભીરતા જોતા અરજદારનો આ ગુનામાં રોલ ધ્યાને લેતા તેમજ ઉપરોક્ત નામદાર સુપ્રીમ કોર્ટના જજમેન્ટમાં પ્રતિપાદિત થયેલા સિદ્ધાંતો જોતા હાલના અરજદારને આગોતરા જામીન ઉપર મુક્ત કરવામાં આવે તો તપાસને હેમ્પર થાય તેવું જણાતું નથી, જેથી અરજદારને કેટલીક શરતોને આધીન આગોતરા જામીન મુક્ત કરવા ન્યાયસંગત જણાતું હોય આ આગોતરા જામીન અરજી મંજૂર કરતા નીચે મુજબનો હુકમ કરવામાં આવે છે. Therefore, my lords, my third submission is no specific reason has been assigned, nor the London Sessions Court had considered the affidavit filed by the investigating officer, my lords. We don't have the affidavit, therefore we have not annexed it in the memo along with the annexures.
Yes.
But it is a procedure that the IO is required to file an affidavit in an anticipatory bail application.
After considering the stand of IO,
Please,
London
please,
judge has
Malus.
granted
But
it.
Sessions Court had not considered the affidavit, nor he has mentioned that he has considered, Malus, in his order, Malus. my lords, and the reason which is assigned is that ઉપર મુજબના પેરામીટર જોતા કિસ્સામાં ગુનાની ગંભીરતા જોતા અરજદારનો આ ગુનામાં રોલ ધ્યાને લેતા તેમજ ઉપરોક્ત નામદાર સુપ્રીમ કોર્ટના જજમેન્ટના પ્રતિપાદિત થયેલા સિદ્ધાંતો જોતા therefore my lords no specific or I would say no clear order has been passed, my lords. So the order which is passed by the London Sessions Court is, in my respectful submission, subject to the correction, it is a stereotype order, my lord. No specific reason, no specific role has been assigned, nor it is mentioned in the affidavit.
Yes.
Therefore, it is clear-cut violation of the judgment of the Honorable Apex Court, my lords. Recent judgment is that Ramesh Bhavan Rathod versus Vishan Bhai Hira Bhai Makwana. In that, the reported in 2021, volume 6 SCC, page number 230, my lords. In this judgment, my lords, Honorable Apex Court has directed the subordinate court to pass an reasoned bail order, not this stereotype order, which is mentioned in paragraph 6, my lords, at page number 25. No specific order has been passed, only stereotype order in my respectful submission is passed, my lords. And considering the grievousness of the offense and the loss suffered to the victim, my lords, because of the negligence or because of his intentional act, that is also not considered by the London Sessions Court, my lords. And my lords, for addition of initially the FIR was came to be registered under the provision of 338, my lords. Thereafter 306 came to be inserted, my lords. Therefore, without the petitioner has to take the respondent number 1 has to take prior permission of the magistrate court before applying for anticipatory bail, my lords, as per my humble full submission, because the law of addition of section is that the IO has to take permission from the magistrate before making an arrest in the case of insertion of a new section. In this case, IO has not taken any permission. Therefore, the order the application filed by the respondent number 1 is not permissible. Yes, sir, my lords.
Anything further?
Please,
Goswami is here. Mr. Goswami is in the campus.
please, my lords.
Yes, violation of any condition? Yeah.
Apart from what my learned friend has argued, qua non. Please.
Criminal miscellaneous application 3069. Please have 30692 of 2017. The present application under section 439(2) of Code of Criminal Procedure is filed for seeking cancellation of anticipatory bail granted by the learned District and Sessions Judge Dahod in criminal miscellaneous application 935 of 2017 on 23rd September 2017. The case of the petitioner is that on 22nd June 2017, when Mr. Vikram Kanubhai Damo was getting married in village Ablot, wherein the petitioner as well as the respondent number 1 accused were present. During celebration of the said ceremony, the respondent accused fired 2 gunshots from his licensed firearm, and thereafter the direction of the said fire got changed, in which one Naresh Raichand suffered grievous hurt on both his legs, as well as pellets sprayed in the firing hit him on various parts of the body. Subsequently, the said injured was brought to the hospital in 108 ambulance, and pursuant to the said incident on 23rd June 2017 at Garbada Police Station, the first information report came to be lodged. The petitioner, the respondent number 2, respondent 1, being apprehending the arrest, has moved the London Sessions Judge for seeking anticipatory bail under Section 438 of Code of Criminal Procedure, which application was registered as application number 935 of 2017, which came up for consideration before the London Principal Sessions Judge, who by order dated 23rd September 2017 was pleased to grant anticipatory bail in favor of respondent number 1. And it is this order is made the subject matter of present criminal miscellaneous application. The present application appears to have been entertained by issuance of rule way back on 19th December 2017. Thereafter, the same, after being adjourned from time to time, came up for consideration before this honorable court. Today, very the learned advocate Mr. R.J. Goswami had appeared for. Should I mention your name or I am not entertaining? Therefore,
Mr. Goswami's name.
Mr. R.J. Goswami appeared for the applicant and Mr. What's your name?
Nishit Joshi.
Nishit Joshi has appeared for respondent of one accused, whereas the lauded APP Mr. Chintan Dave has represented the state authority. It is the case of the lauded advocate Mr. Goswami that pursuant to this serious incident in which the injured had suffered a lot, and on account of this grievous injury, his leg has been amputated from the thighs by operating on 26th June 2017 and remained in hospital for a couple of days. And as such, the learned judge, while passing the impugned order, has not considered the seriousness of offense in which respondent number 1 has played an active role. It has been further submitted that while passing the impugned order, no proper reasons are assigned, and the stand which has been taken by the investigating officer has also not been properly construed by the learned sessions judge. And as such, the order in question suffers from the vice of non-application of mind. It has further been submitted that while extending the protection of anticipatory bail, the learned sessions judge has also not properly assigned the reasons, and as such, on account of this lack of cogent reasons also, the impugned order deserves to be quashed. It has been further submitted that the parameters which are prescribed by catena of decision while exercising jurisdiction under section 438 of CRPC, the learned session judge has not maintained the same, and by cryptic order, the anticipatory bail has been granted in such a serious offense, and as such has requested to set aside the impugned order. To substantiate his stand, the learned advocate has brought to the notice of, has relied upon the decision of Honorable Apex Court reported in 2021 6 SCC page 230, and has submitted that if the order suffers from lack of reasons, lack of appropriate reasons, the same may be interfered with. And as such, considering the overall circumstance as pointed out, a request is made before the court to set aside the impugned order. As against this, the learned APP, to assist the court, has submitted that the order in question has been passed way back in September 2017, and at present the trial is already commenced and it is at a stage of evidence of prosecution, and the next date of trial is 18 July 2022. And as such,
Of next month, 18th of next month.
18th August 2022. And as such, In view of this long lapse of period, the Honorable Court may pass suitable order in the interest of justice. The learned advocate on behalf of both the sides have candidly submitted that in the instant case, the order which has been passed on 23rd September 2017 and the condition contained therein have not been violated so far, and as such has left it to the discretion of the court. The said stand taken by Lord APP is also adopted by learned advocate Mr. So-and-so appearing on behalf of respondent number 1 as well, and has requested to dismiss the application. After having heard the learned advocates appearing for the parties and having gone material on record, it seems that while exercising the due discretion vested under section 438 of CRPC, the learned session judge has not only considered the circumstances related to the incident and has categorically come to the conclusion at the time when order is passed that there was a lapse of 3 months period in between and the injured was already discharged from the hospital. So far as custodial interrogation aspect is concerned, the learned judge has also applied his mind and said that said custodial interrogation at the time of first arrest has already been undertaken by the police authority. And as such, in the circumstances which are stated, it appears that the learned session judge, while granting anticipatory bail, has applied its mind and the order cannot be said to be perverse in any form. It may be that at the stage of grant of bail, detailed analysis of circumstance or the material is not to be discussed at length, but whatever which has been discussed by the learned session judge reflecting in paragraph 6 is appearing to be prima facie satisfied, and as such it is not proper on the part of learned advocate for the petitioner to contend that the order suffers from lack of reasons, and as such the court is of the opinion that order in question cannot be said to be unjust or improper in any form. Paragraph. At this stage, the court has also taken into consideration the aspect that the conditions which have been engrafted in an order dated 23rd September 2017 undisputedly have not been violated, and it is not the case of state authority or even of the complainant that any liberty is misused under the guise of impugn order. And further, the state authority has not preferred an application for seeking cancellation. Considering overall circumstances of the present case on hand, and more particularly in view of the fact that trial is already set to motion on 18th August 2022, the court is not of the opinion to cancel the anticipatory bail which has been granted way back in September 2017. Paragraph. There appears to be a long lapse of insistence of cancellation after submission of the present application. The first order which has been passed in the present proceeding is of 19th December 2017, and the order set reflects that there is no vigilant steps have been taken by the petitioner to see that at an appropriate time the order of anticipatory bail can be tested by this court. And as such, the order set reflects that from December 2017 till date, no effective steps appear to have been taken. And therefore, after a long passage of time, the court is not inclined to exercise the discretion for cancelling the order, which has already been in continuance right from September 2017. At this stage, one of the decisions delivered by Honorable Apex Court, in which the time factor has also been taken note of, and considering the said said decision of Honorable Apex Court reported in so and so, paragraph 11, I'll give that. Paragraph 11 of the said judgment. This court is of the opinion that this is not a fit case in which the present application deserves to be entertained. At this stage, after considering aforesaid overall circumstance, well, after considering the overall circumstance peculiar in nature, as stated here in above, the judgment which has been tried to be pressed into service of Honorable Apex Court is quite in a different set of circumstance, and therefore the ratio, the said salutary ratio which has been enunciated is not possible to be applied here as a straitjacket formula. And therefore, when facts are quite different, the ratio laid down may have a world of difference in applying. And as such, considering the aforesaid proposition, the case is not made out by the applicant to call for any interference accordingly.